Today's lecture concludes this week's discussion of regional human rights systems with a focus on sub-regional human rights mechanisms, many of which are quite recent in origin. We'll discuss the League of Arab States and the legal instruments and institutions in the human rights area that the League establishes. We'll do the same for the Association of Southeast Asian Nations, or ASEAN, and then we'll turn to some of the sub-regional institutions in Africa that have recently moved into the area of human rights. We'll conclude the lecture with a discussion of some of the prospects and challenges for these relatively new sub-regional human rights systems. Let's start with an overview of the League of Arab States, which was formed at the end of the Second World War to promote many of the goals that you see listed. The League turned its attention to human rights issues, producing in 2004 the Arab Charter on Human Rights. And you see the details about the Charter, including how many countries are party to it when it entered into force, and its creation of a committee of independent experts to review and monitor state implementation. Now, there are a number of positive features of the Charter that I'd like to highlight. So first, it's a legally binding instrument. It's not soft law. It asserts that human rights are a key national concern or national priority, and it reaffirms many of the basic principles of the existing international human rights system, including a key clause indicating that nothing in the Arab Charter in any way limits or impairs rights and freedoms as they're protected either in other international agreements or in national law. Now, there are some potentially problematic aspects of the Charter. Here are a few of them. First, some rights are left to national legislation, which means that they can be defined more narrowly than they are in international law, and I've given you two examples. Secondly, it does not extend many rights to non-citizens, and that could be quite problematic to the extent that those who are non-citizens but nevertheless residing within a country could be subjected to human rights violations. It allows restrictions on the freedom to hold a religion or belief. Restrictions on manifesting a religion or belief are permissible in international human rights law, but not restrictions to hold a religion or belief. Also deviating from the international and regional standards are an absence of a prohibition on cruel, inhuman, or degrading punishments as opposed to treatments. And I think it's fair to say, in general, the Charter reflects the reservations to international human rights instruments that the members of the League of Arab States have made when ratifying those UN documents. And so one might see the Arab Charter as a sub-regional treaty that reduces regional standards. Let's turn to some of the work of the Arab Committee on Human Rights. Some of the positive aspects are that the members of the committee are independent experts. Nevertheless, they also do, many of them, hold government positions at the same time, and that might compromise their independence or impartiality. There is no individual complaints mechanism. It is merely a state reporting process that the committee supervises. And so far, although it's still early days yet, most states have not submitted their initial reports. Other concerns relate to limited participation from NGOs, and also, so far, limited impact on national laws and policies. As a new international body, it may well be too early to evaluate whether these problematic issues will continue over time. Now let's turn to a discussion of ASEAN, a sub-regional organization in Southeast Asia. Here too, we see a recent move into the area of human rights. It's even more recent than the Arab League. ASEAN's 10 member nations in 2009 created an intergovernmental commission on human rights to promote this area of the law within the subregion, and in 2012 they adopted the ASEAN Human Rights Declaration, which sets forth a series of non-binding principles relating to protected rights and freedoms. So let's consider, as we did with the Arab League, some of the positive aspects and some of the potential shortcomings. Positive aspects of the ASEAN human rights system include the fact that the Commission can serve as a focal point for sub-regional activities, including networking and connections among national human rights institutions, which we'll talk about next week. The declaration reaffirms all of the main rights in the UDHR, and it also adds some other rights that are of particular importance in the sub-region, including economic and social exploitation of children and the rights of those with communicable diseases such as HIV/AIDS. And it's entirely possible that, as with the UDHR before it, the ASEAN Declaration could serve as a template or a baseline for the drafting of a sub-regional treaty that would be binding on ASEAN's 10 member states. Let's, though, consider some of the problematic aspects. So we have an intergovernmental commission that is a political body whose members are accountable to the states that appoint them. So this is a body at which intergovernmental human rights policies are made. The commission operates by consultation and consensus, which in effect gives each state a veto, in the sense that if one state withholds its consensus, then a policy is not adopted, even though a formal vote is not taken. The Commission's mandate is only promotional. That is, it tries to develop an awareness of and respect for human rights, but it does so without the kind of review of state reports or independent investigations or review of complaints from individuals and NGOs that we've seen in other regional systems and in the United Nations system. Other problematic aspects of ASEAN include the manner by which the declaration was drafted. It was done in a rather secretive manner and without much NGO input, which is unlike some other recent efforts at international lawmaking in the human rights area. The declaration might also be criticized on cultural relativist grounds, in that it asserts that the realization of human rights must be considered in the regional and national context that keeps in mind differences in the areas you see on the slide. And it also says that rights must be balanced with the performance of corresponding duties. Now, it's worth noting here that other regional agreements, most notably the African Charter on Human and People's Rights, contain individual duties, but those duties are not balanced against the rights. They are freestanding obligations that can't be used or asserted to limit rights and freedoms. And indeed, we saw the African Court of Human and People's Rights rejecting that interpretation in the case against Tanzania that was studied in a previous lecture. So, let's now turn to the third sub-regional system relating to human rights, and I'll say a word about that before we assess some of the prospects and challenges for these sub-regional mechanisms. The sub-regional organizations in Africa that are tasked in general with promoting economic and political integration, free trade, potentially a common currency, a customs union, tax harmonization, and so forth. These are some of those sub-regional organizations, ECOWAS, the East African Community, and SADC, the Southern African Development Community. These sub-regional organizations were established to promote economic cooperation, but over time they have begun to move into human rights. And the linchpin for that move comes from the fact that the principles and objectives of these sub-regional systems include the promotion and protection of human rights. These were objectives that were not featured early on in the lives of these sub-regional organizations and systems, but they've become more prominent over time. And since 2005, the courts or tribunals that are associated with each of these three sub-regional systems have begun to review complaints from individuals and NGOs alleging violations of human rights, mainly those rights that are in the African Charter. And we've seen a rather diverse response to these developments. In ECOWAS, a new protocol was established to give that court in West Africa jurisdiction over human rights issues. In the Eastern and Southern Africa, the court adopted expansive interpretations of its existing jurisdiction to extend to human rights, and governments have responded to these developments in quite varying ways. This is a topic that would require its own series of lectures, and I've written some of my own scholarship on these developments, which I'll share with you at the end of the lecture. But I think it's fair to say that the responses have ranged all the way from compliance with some of the decisions of these sub-regional courts to resistance and backlash. And indeed, in the last couple of years, the SADC tribunal was suspended in part due to its move into the area of human rights. Let's conclude the lecture by turning to an evaluation of these sub-regional human rights systems. And the question that I posed for you, which you can see on the slide, is why these sub-regional systems are generally weaker than those in Africa, Europe, and the Americas. Weaker in one or more respects. Either they have lower standards of rights protections, institutions such as courts or commissions or committees with fewer powers, or higher rates of non-compliance. So let me suggest some possible answers to that question, and I'm sure you can think of others and we can discuss them in the forums. So first, it may very well be that political will explains these differences. That is, that states within these subregions don't have the political will, at least not yet, to provide stronger subregional human rights protection. Another answer might be that these systems are new, some of them extremely recent, and they may evolve over time to become stronger. It's worth noting that the other regional systems we studied in Europe, the Americas, and Africa were themselves slow in getting off the ground. It took several years, in some cases a decade or two, before they began to work fully and more effectively. And so one shouldn't judge prematurely whether these initiatives at the sub-regional level are going to work or not. A third potential answer is that human rights violations are more pervasive in these subregions. I'm not sure how persuasive this answer is, since one could make similar arguments about different types of violations in other regions of the world. So I'm not sure it's fair to say that the violations are so different in any of these subregions that they would explain the different results. It's particularly true for those subregions in Africa where the member states of those subregional organizations are also members, many of them, of the African human rights system subject to the jurisdiction of the African Court of Human and People's Rights. Finally, one potential explanation might be that domestic constitutions or legal systems or civil society groups are weaker in these states. And here too, I would say to you that this is an empirical question. It is a question that ought to be investigated rather than assumed, as with the potential answer about violations being more pervasive or more systematic. I'll conclude the lecture by giving you some references to additional recent scholarship on these sub-regional developments. And you can see that the writings are really quite recent, so this is very much on the cutting edge of how human rights law may evolve in the coming years.